I'm Matt Guichard, and this is No Holds Barred. In this episode, we're going to talk about waivers of liability, when they're enforceable and when they're not. Many of you have recently seen in the news about the submersible that was on a tour of the Titanic wreckage in the ocean. And 5 people perished in that submersible. And the question immediately arose, perhaps by lawyers or people interested, is, well, wait a minute, I wonder, is somebody liable? Is what happened there? We certainly know that it imploded. And we know that there's an investigation ongoing. They recovered a portion of it, and I think sometime in the not too distant future, we're going to learn a lot more about why it imploded. The question from a legal standpoint, however, is who is liable, if anyone, for that loss of life? And the question is, did those at least 4 individuals, I understand one was the owner of the company, I doubt he signed a liability waiver, but did he require that the other 4 who went down in that submersible file a waiver of liability? And what exactly is a waiver of liability? And you can look up on Google if you like. You can research on your own. And I'm sure all of you have experience with waivers of liability. You've rented skis and boots and you sign a waiver of liability. You go to the gym and you work out and you sign, it's required, a waiver of liability. You rent some jet skis, you're going to take, you rent a car, waivers of liability. And what is that? That is a legal document that in effect, hopefully, advises you of the potential dangers, the things that can happen, and it then provides you with the ability to sign this waiver saying, I'm accepting the dangers, I'm accepting the potential problems here, up to and including perhaps death. And but nevertheless, I want to engage in that activity and I will sign that waiver. In some cases, the waivers have an indemnity agreement that says, and if somebody gets sued, and I'm going to indemnify this other party because I didn't, they didn't cause the problem, I caused the problem. So you can see these can be very complicated over time. How many of you have had an operation and before the operation, you sign that you appreciate when they're taking your tonsils out, that in fact, everything from losing your voice to losing your life. And you sign that medical waiver before, that consent to that surgery. So oftentimes people can talk about a waiver as a consent to something. Now, are they enforceable? Well, in many cases, yes indeed, in the state of California, there's some pretty strong law that protects the renter of the property, the person at the gym, whatever, because of your knowing and intelligent waiver. And a waiver of liability must be clear. So when somebody reads it, it must be clear. It must be unambiguous and explicit in expressing the party who's signing it, that they understand. Many courts in California have ruled that waivers printed in faint or small font are really not enforceable. And you often think about it of somebody going to a baseball game, and there were a number of cases years ago where you get that ticket and you can't even read the print on the back of it, but there's a waiver on that. And that waiver is not enforceable if somebody can't read it, it's faint, somebody brings an action. Now, there's different rules with respect to a baseball game. Person down that third base line on a line drive hits him in the noggin and seriously injures them. There is what we call an assumption of the risk, which is kind of a different issue that relates to the same kind of thing, suffering, damage. So even if the ticket has such small font that you can't really read it, but you do assume the risk when you go to a baseball game, if you know anything, that those balls are pretty hard and one can come in the stands and injure you. And you see netting around a certain portion, but the baseball teams can't completely net everything so that the crowd can't see. There are areas where we know balls fly into the stands, and sadly you often see somebody holding that drink in their hands, talking to their friend, and take a hard ball to the side of their head. In most cases, it's found that they assumed that risk. But getting back to the liability waivers, you need to have it clear and unambiguous. Let's talk about that submersible. Very, very dangerous to go down, no matter what kind of ship you were in, a submarine, that particular submersible, or whatever. Everyone knew that this was dangerous. If there was a waiver that they all signed, is that waiver something that's supported by law? I don't know. I haven't read that particular waiver. But let's talk about, was there some ordinary negligence on the part of the owner of that? Or was there some kind of gross negligence that perhaps would overcome the waiver of liability? Those are issues that often come up with waivers. Is there some ordinary negligence, or did the owner of that submersible say that, yeah, a number of people have told me this thing is really dangerous. It's gone down a few times and we've had some problems with it. We've got some engineers that have told me that I kind of shortcutted how we built this thing and it's too dangerous, and they told me they'd never get in it. And if somebody signed a regular waiver of liability, a standard one, and that's not in there, can the families bring actions against the company of that submersible? Good question. Stay tuned for that. We'll have to find out. But in general waivers, when you go to the gym and you injure yourself working out, or you drop a weight on your head or something like that, the gym is absolved of liability because you signed a waiver. I did have a case at one time involving a recreational activity, and there was a waiver which was poorly drawn up, certainly didn't advise the participant any of the inherent dangers, and he had signed that waiver. And fast forward a couple of years, a new company purchased that company. They had their own beautiful waivers, but they never went back to the original customers to have them sign waivers. As luck would have it, the person that I'm talking about was seriously injured. The company attempted to use its new waiver, saying, here's our waiver, look, this is totally, the waiver that the client signed was not that waiver. It was a defective waiver, and liability was found against that recreational company. So that's how things can happen. We look at these cases and we often think about the various kinds of liabilities that we all engage in. And there's certainly a question of a potentially dangerous activity. So let's say you're a skydiver. And I will say I used to jump out of perfectly good airplanes. I certainly don't do it anymore, but I certainly signed a waiver when I jumped out of that airplane, hoping, of course, that I didn't pack my chute, that whoever packed it had packed it properly, that everything would happen. And lo and behold, the times that I jumped, I actually, I wouldn't be here if I didn't survive, so I survived. But I did sign those waivers, and inherently dangerous activity. However, those waivers of liability were valid because I knew the danger, and I signed that I knew the danger, And nevertheless, I engaged in that kind of activity. So the same kind of issue I would expect with that submersible, I would venture to guess. The California Supreme Court in the city of Santa Barbara versus Superior Court of Santa Barbara explained the difference between ordinary negligence and gross negligence, really as it relates to conduct, recreational conduct and all, and kind of, if it's ordinary negligence, then the waiver certainly is valid. If there is, however, gross negligence on the part of, let's say, the gym in some fashion, they have a machine, they know it's broken, the cables can cause a great deal of damage, and they just don't care. They say, well, we're not going to put a sign on it, we're going to let people continue to use it because the repairman can't come in a couple of days. And that machine then breaks and severely injures somebody at the gym, and the people at the gym know and knew that if that machine malfunctioned in some fashion, it could, in fact, seriously injure somebody. And is that gross negligence? Certainly sounds like it. Does that simple waiver of liability shield that gym? Probably not. But those are questions that if you're involved in these kinds of things, you need to ponder. But keep in mind, all of the activities that we're all involved with over the course of our lives, particularly when we're on vacation, we're ziplining, we're going out on the boat, we're surfing, all of those things. In most cases, you sign a waiver. In most cases, nobody reads the waiver, but it doesn't matter. If you took the time to have it put in front of you and to actually sign it, you don't get to say, well, I signed it, but I never read it. The fact of the matter is, if you sign it, it's as good as read. And if you're injured in the activity, in most cases, you have no cause of action. I do want to say one case that I recall very specifically is when people were skiing. Somebody rented skis, signed a waiver, they were skiing, and another skier came down the hill and ran into them and seriously injured them. And they sued the people that had that rented them the skis, who also owned the company. Well, guess what? Sorry. Assumption of the risk. They had a cause of action perhaps against the other skier, but not against the people that rented them the skis, or certainly the company that owned the place where they went skiing. So that is an assumption of the risk that has nothing to do with the waiver issue, but sometimes people mix them up, just like I was saying in the baseball game. So those of you, read those waivers, and when you get involved in something, don't go down in a submersible to look at the Titanic if you don't have a very solid waiver. And actually, my own personal advice is, don't go down in that submersible in any case. If you enjoyed this episode of No Holds Barred, please hit the like button and hit the subscribe button. Read those waivers carefully. If you have any questions, put them below. I enjoy reading them, and I will respond to them in future No Holds Barred episodes.